One of my favorite sayings is known as Hanlon's razor. To paraphrase it, some people are malicious, but it's more likely they're just stupid. That might be at the heart of a lawsuit against the New York Times brought by Sarah Palin. She's suing the Times for libel and defamation. This started with a Times editorial from 2017 titled America's Lethal Politics. It was published right after a shooting in Alexandria, Virginia. You may remember 24 Republican congressmen were practicing for the annual congressional baseball game. The shooting severely wounded Congressman Steve Scalise. Turns out the attacker had a history of anti-Republican activities. The New York Times editorial questioned just how vicious American politics had become. It brought up a shooting in Arizona from 2011. That was the attack that wounded Democratic Congresswoman Gabby Giffords. Here's where the malice versus stupidity thing comes into play. The editorial in the Times implied a link between the shooting of Congresswoman Giffords and a map circulated by Sarah Palin's Political Action Committee. Now, that version was corrected the next day, and the Times correction noted that the original version, quote, incorrectly stated that a link existed between political rhetoric and the 2011 shooting of Representative Gabby Giffords. In fact, no such link was established, unquote. The correction does not mention Ms. Palin by name, but she claimed that the editorial made her feel, in her words, powerless, and her team stressed that the Times did not apologize. In his closing statement today, the paper's attorney called the case incredibly important because, quote, it is about the freedom of the press, unquote. And the Times maintains that the corrected text was just a mistake. NBC News legal analyst Danny Cevallos joins us now to break down the case. Danny, did anything from the trial stand out to you that might hint at how it will turn out?
Yes and no. In a sense, there wasn't much to be tried in this case because everything is literally already in black and white. We know what the article says. We know what the Times printed almost just a day later. They have essentially admitted it was a mistake. Even Sarah Palin's testimony really was more about her damages. It wasn't about liability in the sense that nothing she was going to say would change what the Times printed and then what they unprinted or took back the next day. So the only real question for the jury is really the application of these facts to the law and whether or not this mistake amounted to reckless disregard for the truth, which is called constitutional malice after a case called New York Times v. Sullivan way back in the 60s, the Supreme Court case. That's the standard that a public figure like Sarah Palin has to prove. If you're just a private figure, someone who isn't in the spotlight, all you have to show is negligence. But if you're famous, and Sarah Palin's one of the most famous people among public figures, she's going to have to prove a higher burden, and that is reckless disregard, not just negligence, but that essentially the reporters stuck their fingers in their ears, closed their eyes to the truth, and plowed on ahead.
Since we've got this case, I think people kind of throw the words libel and slander and defamation around without a lot of precision. Can you just define those for us real fast? What are libel and slander and defamation? How do we differentiate those from just somebody who insults you or who satirizes you?
I am so glad you asked that question because defamation law may be one of the most misunderstood areas by the public. If you ask any lawyer how many calls they've gotten from someone who claims that their Aunt Edna defamed them on Facebook and they want to sue, every lawyer is going to tell you that they've gotten that call. Then ask the second question. How many of those lawyers have taken that case? It's going to be 0.0. And I'll tell you why. Because the vast majority of defamation cases may exist in theory, but practically speaking, they're not interesting or palatable to an attorney. And that's because, for the most part, a private person defamed by another private person who probably lives in mom's basement, that person doesn't have any assets to go after. And since the New York Times doesn't write about people that aren't newsworthy, a private figure isn't often going to find themselves suing the Times. It's these cases, Palin v. Times, and defamation is the main category. Libel is basically written, slander is spoken, but they're both defamation. It is a false statement that causes somebody harm when it's published. And the standard, of course, normally the baseline is negligence. But the reality is most of these major cases involve public figures. So someone like Sarah Palin has to prove by clear and convincing evidence that the Times or the people, the authors or architects of this article were recklessly disregarding the truth. Not just that they didn't meet journalistic standards, because that's negligence. They have to do a lot more than that, which is why most legal experts have and observers have said that Sarah Palin has an uphill battle here. But her battle is not so much legal. She knows that she is rolling the dice and could potentially deal a huge blow to a branch of journalism that she's not a fan of.
And before I got to let you go, Danny, the Times lawyer's assertion that this is about freedom of the press, that there could be big implications here. What do you make of that?
I was a little surprised that they were allowed to go into that in closing, because they're essentially saying to the jury, you know, hey, forget what we may have said. Think about the harm to all of journalism if you rule against us. I mean, this case is really just about, look at this article, look at the words, you've heard the testimony, and you've seen the emails from the Times internally. And I'm a little concerned for the Times, and they should be too, because they are going to be, the jury now has seen the innards of journalism, with the way we crash deadlines, the fast pace at which journalism and newspapers have to work to meet deadlines. And I wonder, will the jury be shocked at that? Will it jive with their pace of work? And will they think, oh, if you work that fast, it's got to be negligent. It maybe is even reckless. I'm not sure. But if you read the jury instructions objectively, Sarah Palin has a very difficult uphill climb.
NBC News legal analyst Danny Cevallos. Appreciate you explaining that to us, Danny. Thanks very much.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.